share views and learn from them. And also, of course, under your leadership, Mr. Chub, we read about you as well.
Thank you so much for joining.
Thank you.
Lomesh Kiran Nidumuri, please introduce yourself.
Hi, Mr. Navneet. Hi, Mr. Mata. Hi, everyone. Warm welcome to all of you. So my name is Lomesh, and I head the disputes practice for the south of India for Cyril Amachan Mangaldas. So mine is a broad range of practice, including a lot of ADR work that I do as well.
Thank you.
Hi, I am Lakshmi. I run Apex Law Chambers with two other partners. We're a full service law firm. We do a lot of different things. I have primarily been a real estate lawyer, and now I'm into various practices, including a lot of arbitration and mediation proceedings.
Right. Thank you for joining. Advocate Raman Baba he'll join us soon. And any other panelists?
Mr. Jayasima, I believe.
Yes, Mr. Jayasima, please introduce yourself. Please introduce yourself. Okay, all right, good. So the topic today is 70 million cases, pending cases, and how do we resolve them? And I guess one of the solutions is ADR. I wanted to focus on today's panel on ADR, what's working, what's not, how is actually ADR working. I know there's a lot of conversation about it, and it's picked up maybe what, 10 years ago or so. And what are the pitfalls? What is good that's going on with ADR? I know there's a lot of conversation. Mr. Kumar Mata, I'll start with you. So, in your experience so far, do you believe lawyers and judges are actively taking on ADR, and is it becoming a choice way to resolve disputes?
It's a very broad canvas question. Let me just give a couple of minutes of history to this. The Mediation Act has yet been enforced partly. It's not fully functional, 2023. The Arbitration Act since 1996 and with a few amendments. I'm speaking specifically regarding the Delhi High Court and its environments, because that's where we are basically based. The Delhi High Court started a mediation cell, and I'm lucky I was one of the first batch of trained mediators and a senior mediator trained as well. Done close to 300 mediations, including those under the aegis of the Supreme Court. So mediation has gathered, I wouldn't say steam, which has gathered a bit of momentum, not sufficient as yet. Coming to your question, Navneet, ADR. To my mind, arbitration or litigation isn't really ADR, because that's really conflict. That's coming the flow. Mediation is still largely taken as a very casual exercise. There are very good trained mediators, but mediation doesn't work unless counsel on both sides see realistic issues. And I'm not saying every client is going to be advised. I'm familiar with a lot of mediation in certain other jurisdictions where it's taken much more intensely. Maybe senior counsel are engaged for mediation, not the practice here. So broadly answering the question at this stage, the other panelists, their views, I'll respect their views and learn from them. Mediation should be the core thrust right now, not arbitration, not courts. We already know the experience of these two environments. So if mediation can be put into more effective, let's say, impact, it will. It's not a dispute settlement. It's actually a voluntary settlement. It's not a third party who decides what is right and what is wrong. You live with it, you lump it, you don't like it, whatever it is. So one advantage of mediation. Second thing is there should be encouragement to mediation in terms of if there are settlements, they invite stamp duties, they invite registrations. There should be some kind of an incentive so that people know if they're doing into. We are looking to mediations across the board. So maybe something could be that way. But really, the stress, according to me, mediation should be the place where a greater stress needs to be placed.
Thank you so much. Mr. Jayasima, if you can please introduce yourself.
Greetings, one and all. Sorry, I joined a few minutes late from Paris. I've just arrived here. And thank you very much for the invitation to be part of this panel. My name is Shreyas Jayasama. I'm a lawyer based in Bangalore. And for the past 27 years, I've been dealing with domestic and international disputes in many parts of the world. And both arbitration, mediation, and other forms, including expert determination, dealt with the investor state issues, commercial issues from a range of sectors, and I'm very keen to learn from other panelists. Thank you, Mr. Chuk, for the invitation.
Thank you for joining us. So Lakshmi, let's take a step back for a minute. We have 70 million pending cases. What, in your view, is the single biggest reason for this backlog?
See, the single biggest backlog in India specifically is we don't have enough judges here. Very few judges with a lot of cases. Also, the judges do not have categorical experience in most places when cases are being heard, especially at a very lower level. High court judges and Supreme Court judges, they have enough practice and they come with a lot of knowledge base to handle these cases. And but at a very junior level, where usually all litigation goes and starts, at that level, there is not enough expertise to handle all kinds of litigations. So there's a time drag because of inexpertise in the judges, and also there are not enough number of judges in place, firstly, and there is no set procedure on nowadays. I know that in commercial courts there is a compulsory mediation push that happens, but that is only in commercial courts, right? Like not everywhere else. So adaptation of more of a like Mata sir said, like more of a mediation push will help these backlogs. But the backlog is basically majorly because of not enough judges in place and not enough expertise by these judges.
Good, thank you. So ask a question to Mr. Nidumuri. What, in your experience, what kind of cases are best suited to be resolved through ADR and not court litigation, in your experience?
Yeah, thank you so much, Mr. Chuk, and hi Shreyas, hi Lakshmi. It's good to see more of the Bangalore bar also on this webinar. They're all my friends, so it's good to see them here. To answer your question, Mr. Chuk, I believe that all types of cases are capable of being settled. I don't think there is any specific area where you can carve out and say that these cases cannot be settled. But typically, if you're looking at just broad litigation, if you're not looking at commercial disputes, obviously when it involves a little more emotions, for instance, such as family disputes, matrimonial disputes, those are certainly capable of getting resolved. If it is commercial disputes, they are also capable of getting resolved. because ultimately it's a question of the bargaining power of each party. And there is always a stickling point between the parties, which needs a trained mediator to look into the genesis of things to identify the issue so that the matter can be resolved. So it really doesn't boil down to any genre of cases, but I think it really comes down to having a robust mechanism where you have a trained mediator who understands the pulse of the dispute very, very well, who's able to understand that sometimes a lot of litigations are also fought because of ego. There may not really be any merit in it, but it is the ability of the mediator to get the parties closer, identify the issues, and put it to them to see how best you can resolve it. And in my experience, I have seen a lot of commercial disputes as well, where a trained mediator has been able to just break the ice, including through some connections that are at the human level, where they were able to just break the ice between two business partners who have been fighting. The arbitrator in this case understood what the genesis was and was able to also refer it to mediation and get the case settled. So I think broadly, I would say that all types of cases are capable of, and I would not put any case beyond settlement. We also go back to, you know, Mahatma Gandhi's My Experiments in Truth, right? So his experiences in South Africa and some of the things that he writes in the book are just beautiful to read. In that case, he had a decree in favor of one of his clients, and how he told the client not to litigate and to actually settle for a little lesser because they were able to actually maintain the relationships going forward is actually a beautiful excerpt to actually read. There are multiple instances in that book which I think really touched me, and it's a lesson for all of us taking things forward.
Good, thank you. So, just so you know, we broadcast our webinars on LinkedIn and Facebook and YouTube. So there's a lot of other people watching, and we get questions from all the platforms. And most of our webinars in the past, we've given our panelists some questions in advance, or we talk to them and ask them what questions to ask them. But given that we're on various platforms, what our audience prefers and likes the most is that we ask the questions that they want asked. So lately, we've decided to let our audience control the webinars. And of course, we have conversation amongst the panelists as well. So thank you for joining us and not bugging us to give you questions in advance. And so zero preparation. So I want the audience to know how good you all are. And the questions that I'm reading are questions I'm reading for the first time and you're listening to for the first time and answering. So Shreyas, there are a bunch of youngsters that are listening to us. And one of them wants to know, how does this ADR process work? So you get a client, you file a lawsuit, and then how does it end up in ADR? Do you start? Does the other side start? Does the judge force you to, or how does it start?
Thank you again, Namni ji. When you say young, my experience in ADR has been that interest is expressed by people of all ages and all backgrounds, retired bureaucrats, judges, all backgrounds, professionals, engineers have shown a youngster-like interest in ADR. So therefore, this question may not necessarily be from a person who's young in age only. The systems differ, but broadly fall in uh, predictable categories. Either the parties can contractually agree that there ought to be a procedure that is applied, for example, pre-dispute, to submit it to a form of ADR, which could be mediation, it could be, as I said earlier, early neutral evaluation, expert determination, some forms of dispute resolution that are outside of the typical litigation scenario. Uh, Arbitration is still, in my view, a form of ADR. It's not to be excluded. and lumped only with litigation. There are very distinct features between arbitration and litigation. And to that extent, I would like to reframe at all times ADR as appropriate dispute resolution and not alternate dispute resolution only. And agency therefore remains with the parties the moment you see it as appropriate. The agency is never lost. Even if your clause does not have all of this, nothing stops the parties. In your scenario, Mr. Chug, when the litigation is commenced for any reason, for a party then to reach across the table and propose a model of dispute resolution, and if it is accepted by the other side, then it can proceed. In India, the third instance exists where under the Section 89 of the Civil Procedure Code, and then replicated in many other statutes subsequently, the court can recognize that the parties are in a scenario which is appropriate for mediation, and it can direct parties to go into mediation. This power may not exist in some other jurisdictions, but it does exist in India. And that does not mean that the court can compel parties to actually settle. They are only compelling an attempt to settle. And this broadly is the approach that you should be familiar with. And I want to just leave you with the underlining the aspect of agency. Every litigation or arbitration or mediation is unique, and we have to be creative in deploying the appropriate tools to resolve such conflicts.
So, what percentage of cases that you're handling now in your practice are you're doing some process through ADR?
I would say practically all of them, it is discussed as an option, whether it's actually pursued, whether it is deferred, and sometimes a very fresh young colleague can be nervous, and they have asked me, as we say, a mufat or a frank question to say, what on earth are you doing attempting to resolve all these cases? What's going to remain in the office? And I have to often counsel such anxious minds to say it's far better to be in the practice of deploying what leverage you can achieve through your other means, but actually resolve the conflicts. So I would say nearly all our commercial disputes have gone through some ADR analysis, and happily some of the clients are open to it. And as Lomesh here has said, and Lakshmi knows, Bangalore in particular has a very convivial, amiable bar, and we can easily reach across each other to seek to resolve. And of course, Mr. Mata, I've not met before. Namaste, sir. And it is, of course, the litigating cultures in different cities are not the same. And at least my experience in Delhi and in Mumbai, sometimes there can be some resistance to mediation or settlement from the parties themselves, and therefore lawyers are hesitant to push the envelope at the risk of losing their client. And but I'm sure all of that is subject to change with seniors like Mr. Mata playing the role of neutrals.
Very good. Our ILA Alwar President Gitesh Khanna has a question for you, Shreyas. Go ahead, Mr. Khanna.
So, in your experience, at what point does mediator neutrality risk becoming ineffective, and how do you balance strict neutrality with the need to actively intervene when a power imbalance threatens the integrity of the process?
I'll leave it to Mr. Mata with his experience to say more. But from my quick response, I trained as a mediator in 2008, and I think it's only a half joke to say that mediation and meditation sound and seem alike. Only those with the courage to face inner conflict can truly help resolve conflict on the outside. And that goes to your point on neutrality. and recognizing the unequal positions of parties early is part of the repertoire of skills of a mediator, and who will then be, he or she will be able to deploy appropriate tools to make sure that all parties feel comfortable that they have voiced their positions, and then the mediator is trained to understand how those positions can be aligned to their long-term interests. And so this alignment of interests and positions is what the creative work of the mediator is. And the unequal parties' positions is normal. It is not unusual. And mere inequality in positions does not impair the neutrality of the mediator, in my view. But I pass it on to Mr. Mata for any further comment.
Go ahead,
No,
Mr. Math.
very well put. Just dotting the I's and the T's. My experience, and I'll just put it very briefly. As I said, I've done mediation since 2006. I'm a trained senior mediator, currently also doing mediations apart from my other work. The first thing that I endeavor to do as a mediator, and I respect the views of others, they have their own ways and better perhaps. I first sit in the group of people as friends. I'm no longer a lawyer. I know nothing of the law. I know none of the parties. And I just try to become a part of the group. You can share a cup of coffee, sit together like a group of friends. No sitting on one side and stuff like that. That's the first thing. Second thing, I encourage the parties to bring in any friends, any well-wishers, any people who they trust, whose judgments they rely upon, or anybody who could be a go-between. That's the second effort. I'm going to take a minute or two longer. Number of cases come where it's a non-starter to begin with. Parties have actually just come to mediation. I'm being candid. कोर्ट में तारीख चाहिए mediation के लिए चले जाते हैं. That's a reality. Let's not kind of ignore that. That's a reality. Sometimes the judge doesn't want to do something. He says, okay, try mediation. He feels it's better, the matter is settled. So there are a number of cases, percentages I don't want to speculate, where it's a non-starter to begin with. Those are the harder nuts. Because you've got to make out whether there is going to be purposeful mediation or actually they just come here to go back. So that's the first thing. But once you see that the parties are willing to talk, the imbalance becomes important where the stakes are very high or where the imbalance is extremely acute. But if you have, as Mr. Jayasima said, over a period of time, if you gain their confidence and they start seeing, and as I said, lawyers are very important. Lawyers are the one who will advise the client that, look here, this is where we could perhaps settle at this stage, or this is where we will not get more. Whether it's a mediation referred through arbitration or through court, it's at that stage. So a mediator has to first win confidence, win trust. And then, of course, Jayasima said, there are so many innovative ways a mediator can come about, and very well put by him. So I think that's where I just supplement that. That's all.
But that is the basic ethics of the mediator defined. Uh, we have to in a mediation, when we are sitting as a mediator, then we should forget everything. We should forget we are a mediator, we are a lawyer, we are anything, and we should be a person, a friend of the two parties, the other two parties sitting in the front. But I was asking something differently. How does the neutrality affects the integrity of the process?
Neutrality of the mediator, do I understand that right?
So neutrality of the process.
I'm not able to actually gauge what that expression would mean. What would you mean by neutrality of the process? Just explain to me. Perhaps I'm not getting it.
So at what point does mediator neutrality risk becoming ineffective? I'm repeating the question.
Yeah, please do that. Yeah.
So at what point does mediator neutrality risk becoming ineffective, and how do you balance strict neutrality with the need to actively intervene when a power imbalance threatens the integrity of the process? So when there is a
Let me ask,
power,
Mr. Khanna, let me ask Lakshmi this question on what you're asking. So, Lakshmi, in your experience, do you think our clients, your clients, do they feel that they can trust the mediator, that the mediator will be a neutral person and will not take bribes from one side? Is the trust increasing in mediation?
Hello, sorry, I couldn't. There was a lag. I could not hear the question completely.
So I'm asking you, Lakshmi, that is the trust in the mediation process increasing in the country, or your clients feeling that they cannot trust one independent person to be a mediator, an impartial person, and somebody else will have an impact on them or affect them in some way? Are your clients believing in the mediation process now?
See, I will answer in two folds. One, yes, in affirmative, most of the clients do believe in mediation. Uh, when it is a court pushed mediation or a court directed mediation, the belief may come at a later point only if the clients or the people who are participating have an open mind. But most of the mediations start with an intention to mediate by the parties itself, right? So they already come prepared for a third person to sit and mediate their issues. So I wouldn't see that as a major problem, but yes, there is power inflection between two parties. One has a higher power, one has a lower power, majorly because of the contractual, insights they have. One has a weaker case, one has a higher case. But the idea of mediation when they're coming there is to sit and talk through it and balance that power. Okay, so the idea is to come to a settlement. It is not about who has higher power, it is about how to neutralize that power, and mediator is the person who helps them do that. So there is already enough belief in the system when they're coming to it, because it is not somebody pushing them to do it, it is them choosing to do it. So they believe in the mediator to neutralize that power.
Can I just come in for a moment? Sorry,
Yes.
I think I apologize again. So there are two parts. One is, as I understand, one is the merit imbalance, and one is the party's strength imbalance. Coming to the party's strength imbalance, if the weaker party has a feeling that the mediator is perhaps not pushing it fairly, the weaker party will just walk off because they've got lawyers there. Their lawyers are also sensing. Ultimately, most mediators which are there who are annexed to court mediations, they're all lawyers, trained mediators. So the lawyers will be able to sense that my party has, is weak in the party sense. They have a good case, but still weak in a party sense. And the mediators perhaps trying to push a settlement, which may not be very fair or very equitable. They'll just walk off. And that's the experience that I'm seeing, which is why mediators endeavor. I mean, I'm telling you the practice that we follow. We have no connect with any of the counsel or the parties ever. You can't reach us. You need to reach us coming through the mediation center. No contact, no mobiles, no emails, nothing. We come across each other in the court corridors. We just nod, acknowledge, and have an exchange of pleasantry. Hello, how are you? That's it. So I think it's really left to the mediator herself or himself to be able to take care of that. And your experience, I'm sure you've gone through a lot of those as well.
Thank you. So Lomesh, a question for you. When I'm doing agreements, and I've heard this from many other lawyers, when we're doing agreements between two big companies in India, and especially between India and another foreign country, invariably the jurisdiction is put as Singapore or London or Hong Kong when it comes to mediation, and not India. It's one of the things that irritates me the most when learned, experienced general counsels in India are putting Dubai and London, Singapore, Hong Kong as centers where arbitration will be done. And I remember in 1959 or 60 when Singapore was born, how much India helped Singapore get going. And now a country of 1.4 billion people, 2 million lawyers, and we can't trust our own to do arbitration and mediation for cases that are arising in India. What do we have to do?
Okay, thank you so much, Mr. Chuk, for that question. I think I'll need 2 hours to answer this, but I'll try to answer it in 2 minutes. It's a challenge because it's a very, very broad and open-ended question. I have much to say on this. You're absolutely right that the trend typically is, and it depends on who has the higher bargaining power. If it is a foreign party who's putting in money into an Indian company, typically the party that is putting in the money would say, I want a foreign seat. And then it would come down to a negotiation between the Indian counterpart and the foreign counterpart to see whether the seat of arbitration can be abroad or can it be in India. Now, there are few reasons as to why the arbitration is chosen out of India. And there are empirical analysis in terms of analysis of judicial precedents as well on this. Now, typically, when you choose a foreign seat, let's say a Singapore, Dubai, London, or any other seat, and the arbitration is conducted there, the challenge to the arbitral award is done in those jurisdictions. And typically, the UNCITRAL model is followed, and arbitral awards are rarely set aside. And then that party has the opportunity of enforcing the foreign arbitral award in India through Part 2 of the Arbitration Act. And empirical analysis would show that foreign arbitral awards in India are very rarely set aside, as opposed to having a seat of arbitration in India where it becomes a domestic arbitration and Part 1, your grounds under Section 34 of the Arbitration Act, where patent illegality and all the other provisions are applicable to a domestic award, whereas it's not really applicable to a foreign award. So I think because of some of these nuances, parties are more than happy to choose a foreign seat. That is one. The second thing is there is also a belief, I'm not saying that it is entirely correct, that if you choose a foreign seat, the choice of arbitrators and the certainty of the entire process of enforcement becomes a lot more seamless. It is partly true because India is a large country, you're dealing with multiple jurisdictions. But I can tell you jurisdictions like Delhi, Bombay, perhaps to some extent Bangalore as well, and Delhi's, that's somewhere Mr. Mata would agree with me, that Delhi High Court, a challenge to an arbitral award, is the time that is taken to decide that is perhaps faster than most leading jurisdictions in the world. But that cannot be said of various other jurisdictions in India where a challenge to an arbitral award itself takes a lot of time. And then comes the choice of arbitrators. In India, the pool of arbitrators that you have is perhaps a little more restricted compared to some of the foreign jurisdictions. But let me tell you, Mr. Chuk, and the panelists also will agree with me, that this trend is changing at a very rapid pace. We are seeing some kind of a trend where parties are agreeing to Indian seated arbitration, agreeing to an Indian arbitrator itself sitting there. And we see a lot of non-retired High Court or Supreme Court judges who are also acting as arbitrators, and some of who can match shoulders with the best in the world. So that trend is also changing. You're seeing a massive pool of younger lawyers who are getting into the market every year. The talent pool that India has is perhaps one of the best in the world. You see some of the Indian lawyers going abroad. They become, heading huge international law firms and also acting as arbitrators. So I would say that the trend is changing. Is it changing fast enough? I don't know. That is up for debate. But certainly there has been a positive change in the Indian arbitration scenario on these aspects. But we certainly have a long way to go.
Good. So, question for you, Shreyas. So you're in Paris, and Paris has a big arbitration, International Court of Arbitration, right? It's the ICC, International Court of Arbitration, that does a majority of the arbitrations mediation in France. And then worldwide, besides ICC, there's SIAC and Hong Kong International Arbitration Center and London Court of International Arbitration. And in United States, AAA, American Arbitration Association, is huge. As there are JAMS, Judicial and Mediation Service, and ADR services, and Judicate West, and 25,000 lawyers are solo practitioners practicing as mediators and arbitration, providing arbitration services. So are there 3 or 4 or 5 decent sized companies? Have they are there 3 or 4 arbitration mediation companies in India that are rising and becoming popular and powerful, and people choosing one of these top 5?
Thank you, Namni. Yes, there are a number of arbitral institutions in India. Many of the high courts themselves have set up arbitration centers. That one of the busiest ones is the Delhi High Court Annexed
One of
Arbitration
these top 5?
Center. I don't have the statistics in front of me, but if you can look at it, it's perhaps got the most number of cases. Many other high courts have that, so that's a real option that parties can look at. The
Arbitration,
ICA is one of the older
providing arbitration
institutions
services.
that has still continued. And then more privately, I've been privileged to be part of the early confabulations of many centers in India, including the MCIA, which is the Mumbai Center for International Arbitration. And I remember debating whether it should be MIAC or MCIA. And then we saw that MAIC was taken by Mauritius, for example, at that time. But they have recently updated their rules, so they are a strong contender. Many of them have incorporated emergency arbitration provisions. I am not a salesman for any one of these centers at all. I'm just an observer, and when I'm invited to contribute, I do. I'm no longer associated with the MCIA as part of the governing council, but I am part
Advocate Raman
currently. I
Baba
think
has he'll
Lomesh,
join
I
us
think, is
soon.
also, correct me if I'm wrong, Lomesh,
And
associated with the
any
governing
other
committee
panelists?
earlier also with Hyderabad, which is the IAMC, and they have a healthy, I would say, focus on not just arbitration, but also to promote mediation in equal measure at the outset. So the rules also reflect that joint consideration. In Chennai, I'm on the board of directors of Nani Palkhiwala Arbitration Center. Again, we're going through a rule revision there. And many of the large Indian conglomerates have found it very comfortable to adopt the NPAC rules. And they also offer a cost structure that is comfortable. I'm mentioning only a few. I would say please exercise healthy caution while choosing institutions anywhere in the world, including in India, and don't go by the title alone. Go by a careful analysis of the content and speak to people about the recent working of these institutions before you make a choice.
Do you have a favorite?
I don't, but I do watch very closely and objectively, because earlier I would have put in an X clause and now I have deleted it. I have chosen Y instead. And that is because of seeing how these institutions work. And as they say with mutual funds, past performance is no guarantee of how the parties and institutions behave in future. So, but I would say that amongst the ones that I mentioned, which are high court supervised, there is a comfort level in parties that there is strong judicial oversight. In entities which want to be up against governments, then they would like to take the cases outside India in the first instance. And otherwise, in India also, they would like to choose an institution that is more privately governed and run. So it depends on the nature of the parties.
Good. When it comes to any agreement with United States, we have a practice at my firm that we put JAMS as default, JAMS. They're very, very good all over the country. as are all the others, Judicate West and ADR and AAA. AAA tends to be a little more pricey than JAMS, but personally and others at my firm, we've had a great experience with JAMS. They also happen to have a few Indian mediators now, lately. Maybe 10 of them now, and 5 years ago they didn't have any. But they're very good. So, Mr. Kumar Mata, this you're obviously familiar with the Delhi High Court arbitration. So my question to you is, why is the High Court getting involved in arbitrations? Shouldn't they be focusing on running the High Court and let other people do this arbitration business?
Navneet, the High Court gets involved in an arbitration typically when either a Section 9 or a Section 11 is brought to the court, which the court has to handle. Section 11 are now almost like two hearing matters. If there's a clause, refer, end of story. Section 9, yeah, it's a bit of a time consuming, depending on the nature of dispute. But ultimately, Section 9 also says interim, whatever it is, the tribunal will take a call, modify whatever. The problem arises when a 34 comes in. 34, my experience is 30% of 34s are disposed of in a couple of hearings. Usually the first hearing is good for even 10 to 15%, where the court does not entertain. Where the government is a respondent in a 34, the obligation to deposit and in a time-bound manner is an obvious thing. So that once the 34s where the challenge stretches long are, depending on the nature of the award, I'm going to be candid, depends upon the constitution of the tribunal as well. Let's be frank about it. Ultimately, we're all humans. We must acknowledge where the truth is. So each bench has its own perception, which is why some 34 benches may take longer and some may actually be quicker. 37 and then SLPs, they are the sequential verticals, which really don't take much time, barring a few here and there.
But why is
So
the
then-
court involved in arbitration, Mr. Kumar Mata?
No,
Mata,
court,
why isn't
when
the
an-
court has other business to do, right? Run the courts.
No, court is not involved in arbitration. The court annexed Delhi High Court's mediation, DIAC. It's an independent body. When a matter is referred to DIAC, that's the end of the matter. The court does not supervise it. It has no control. Nothing is reported to the court. It's an arbitration. It's an institution, another arbitration institution. That's it.
And the arbiters, mediators are retired judges or just attorneys?
Regrettably, many of the arbitrators are former judges, whether of the superior courts or maybe even of district courts. I'm using the word regrettably because it's not necessary that when you retire as a judge and you become an arbitrator, you kind of remove that gown and come with a different mindset. Unfortunately, some of them do carry that, and it's not their fault, but whatever it is, there are many lawyers who are also on the panel of the DIAC as arbitrators. I have been on the panel for a long time, and there are outsiders. They're technical people. I just wanted to share with you. I have been on the Delhi High Court Rules Committee since 2008 or 9. For the last few years, I've been a member of the Rules Committee, and we draft various rules. So amongst the rules for appointment of arbitrators, we have a panel of arbitrators, which could be technical people, engineers, could be scientists, could be whatever else, doctors. So it depends on the nature of matter. The DIAC appoints the arbitrator. High Court does not appoint. High Court simply refers the matter.
And each arbitration is one person, one arbitrator, or more?
Depends on the referral order. If it's a multi-member, then the DIAC will constitute a multi-member tribunal. And if it's a single member, then they will nominate a single member.
Most of the times, it's how many people? One or more?
90% is a single member.
Okay. And you've been you worked as an arbitrator with DIC?
Yes, for many years.
And what does a typical arbitration with DIC single member, what does it cost?
The DIC has a schedule. The payment is made to the DIC by the parties. There is a phased manner of payment to the tribunal at different stages. And the last payment is, of course, based on the award. And it's not a very astronomical sum. It's a very reasonable sum.
Do you recall what it is, or what is it now? If I go to DIAC now and ask for one arbitrator for a medium-sized matter, what would be the charge?
I'm not going to be able to speculate. It's like a percentage of the claim amount. So like up
Okay.
to 5 lakhs is a certain percentage, typically like the tax slabs. It's a percentage of the claim amount with a cap of, I think, 40 or something, 40 lakhs.
Okay. What surprises me, Lomesh, is I was asked to, I don't even know how I got involved, but one day I get a call saying, hey, we have one of our Delhi lawyers working with one of our US lawyers. A divorce ends up in Supreme Court at New Delhi. And the divorce was going on in California as well. And all of a sudden, there's mediation with the Supreme Court of India. And I was shocked that they're getting involved in a divorce. But in any event, I was told, hey, can you join at 10:30 a.m. India time? I said, sure, I joined. And after an hour and a half or two, the mediator says, okay, so we'll meet again in 2 weeks and 3 weeks. And this happened several times. And that to me was very, very strange that if you're going to do mediation, then end it in one day, half a day, and then to carry, just keep delaying it. Then the purpose of arbitration mediation was to cut down on time. And why can't we finish it in one go?
Yeah, so you want me to give my observations also on this?
Yes.
Yeah, okay, got it. So I think it fundamentally comes down to a couple of aspects. Again, one, who your mediator is, and is a mediator trained to handle mediations? I think it comes down to really mediation of both the mediators as well as arbitrators. I believe that just because somebody is a fantastic lawyer, either at the commercial court or at the appellate stage, does not necessarily make them a good arbitration lawyer. That is point one. Secondly, it certainly does not make them a good mediator, because mediation requires a lot of unlearning of all the things that you have learned. It requires you to look at the dispute from a fresh perspective itself. And secondly, there needs to be some professionalism and integrity of the process itself. I think professionalism, both in mediation as well as arbitration, is extremely important. And that, again, from an Indian context, it comes down to luck. You have narrated a bad experience, whereas I've had quite a few good experiences as well with retired High Court and Supreme Court judges. I've had some good experiences with a couple of senior advocates who have acted as mediators, somebody who have understood what the role of a mediator is. Fundamentally, mediator needs to understand is that they are not there to decide the dispute. And which is why a question came from Gitesh Khanna earlier about this whole perception bias and about whether really to power imbalance, etc. The mediator is not there to decide the dispute. The mediator may have his or her own notions about a particular case, but it is not for the mediator to bring that out in the settlement discussions. A trained mediator is somebody who brings the parties together such that the parties talk. It's not about what the mediator tells them what to do. And I think these kind of professionalism aspects, it is a bit of a hit or a miss in India. And I would say that it is a bit of a hit or a miss, not just in India, but in a lot of other jurisdictions as well. Barring very few jurisdictions in the world where I can say that, yes, once you go to mediation, you're rest assured that the entire process is going to be fantastic. It is a learning curve even for India. But I can tell you that from based on my experiences, I've also had good experiences while I've had bad as well.
So Lomesh, in your experience, do your mediation arbitrations, what percentage of them end with one sitting one day, and what percentage carry on to more days?
Yeah, so Again, it depends on the mediator. If the mediator has asked for the copies of the pleadings well in advance, then I would expect the mediator to also read. I've had instances where the mediator has gone through the papers because you also need to understand what the case is. But a lot of times what happens is mediator comes for the first time, which is what has happened in your case as well. And then they ask the parties, tell me what the case is about, you tell me what the case is. Sometimes they ask for some form of written submissions, like a summary of what the case is. And then they have the mediations later on. But typically, I have not seen mediations close in a day itself. That is very, very unusual for it to happen. I've seen that on in certain exceptions, but mostly it is where it goes on for a couple of sittings. And I think the nature of the mediation itself, let's assume that the mediator has also prepared himself or herself really well, and the parties have come before the mediator. I would believe that mediation process itself is so complex that it may not happen just in one sitting, because there are certain points that they may come, issues may get crystallized to 1 or 2 or 3 points, and perhaps the parties may want to go back and check, think, reflect, and again come back. A lot of times, people who are not the decision makers, they may say, I'll have to go check with my boss and then come back, only then I can do it. Mediator may say, why don't you put it on the call right now? A lot of times, where it's a company, it has to be deliberated at the board level. So that is why mediations typically don't finish in a day. But having said that, if it stretches for more than 2 or 3 sittings, I would be extremely concerned about the delays in the whole mediation process. And I would say that not more than 2 or 3 sittings should ideally be required for the entire mediation process, no matter how complex the dispute is.
What
Just
is a typical?
one second,
Yeah,
just to
yeah,
add here.
Lakshmi. Go ahead.
See, mediation or arbitration or any kind of alternative dispute
The
resolution
parties have
system,
come before
the
the
idea is
mediator.
to resolve.
I would
So
believe that
looking at it as a
mediation
fast
process
track
itself is so
option
complex
to,
that
just
it may not
get
happen.
done with the dispute shouldn't be the lookout. The lookout should be to get a proper resolution out of it so that it doesn't repeat, there is no recurrence of it, and it doesn't have to go to the court tomorrow. The idea is to achieve that rather than thinking about how soon we should finish it. I think the mediators also take time out, especially in India when you're talking about a divorce situation. The ideology and the cultural background that we are of, we generally don't agree to a aspect of divorce so easily, right? So given all of these backgrounds, time is not the first thing that comes to anybody's mind. To mediate and to reach an amicable ground for both to decide on how their future should look is what, in most of the cases that I have dealt with, mediators take time. There are 2 to 3 settings that happens. The idea is to, at the end of the day, try and bring the couple together back into their marriage rather than just agreeing to their ask of divorce,
Do you
specifically when it comes to
do you do a lot of family law, Lakshmi?
I do.
Okay.
Navneet
And
ji,
what
just
percentage?
sorry.
Yeah, one second. What percentage of your family law cases get resolved through mediation?
I would say 70 to 80%.
And there's no arbitration in family law, right?
No.
So
We
it's either
typically
court.
prefer mediation in family law disputes.
Right. Okay. Yes, Mr. Mata.
Navneet ji, I just want to share something. When we got trained as mediators, our first training, and we were trained by very eminent mediators, that you have to have the patience of an elephant. You are not going to push. The parties may want time, maybe one hearing, maybe 2 sittings. We call them sittings, actually. We don't call them hearings because we are sitting as friends. So the first lesson we were told was, you do not have to look at your watch, put your phone off, do not accept unless suppose it's really urgent. So the party shouldn't feel that the mediator doesn't have time for me. And like Lakshmi said, in matrimonial matters, I've done some of those as well, where issues are so personal that everybody has gone to the micros. So Lomesh has said, yes, you try not to delay it as long as you're funneling, as long as you're fine tuning and coming to a closure. Then perhaps a sitting or two longer than the first or the second or the third. But if you feel that it's just like putting it to another hearing or another sitting, you are obviously right. It doesn't serve the purpose.
A question for you, Lakshmi, from one of our platforms. What is the average charge that you're paying a mediator to resolve a family law dispute?
That majorly depends on the mediation centers. So you cannot just set a value to it, because most mediation centers work very differently. They have different charges. They have their panel charges, which have already been given prior to when you go for mediation. They will let you know of how much the charges would
But
calculate.
is it 25,000 for a day, or 50,000, or 15, or 100?
It is not usually done like that. It is per sitting. Usually, that's how they charge. It is done in a different fashion. They will charge basis sittings, and also the experience of the mediator also will matter.
Right. So, Shreya has a question for you by Advocate Sampath Tidke. He's an Army veteran. His question to you is, what is the success rate of ADR in India as you think as of now?
The honest answer is I don't know. I have not done that study, but my perception is, and I'm very heartened, and I want to firstly congratulate you, Navneet ji, for pulling India together in this unique way, Indian lawyers together. It's a wonderful initiative. It's the first time I'm encountering it. But it was lovely to hear from Alwar in Rajasthan and now the person with this military background. So perhaps this question can motivate your organization, sir, because you have the resources now of having district level lawyers, and you can put out a survey. If you'd like, I can share with you a link to the survey that I attempted and failed to get elicit an adequate response. I partnered with Ernst & Young and we had a ADR survey, and we couldn't get more than a few hundred responses. So maybe I'll share that with you. And these are all important questions, but it's questions that we need to move away from approximations and guesstimates, because that will impair the trust that parties have on the process. We must, I think, hold ourselves to a more scientific rigor, and rather than provide anecdotal answers just for the sake of this webinar and let the opportunity pass, I would rather seize the opportunity, carpe diem, etc. And why don't we make this as a study which can then come out with a report? And I'm very happy to collaborate with you, Navneet ji.
Sure, that would be wonderful. Gagan Oberoi is a famous lawyer from Chandigarh. He is president of ILA Chandigarh. He's on the call. ILA Mysore President Satya Chetty is on the call. Hopefully they'll ask a question. In the meanwhile, I have a question for you, Lomesh. The question is, in some countries, before parties file a lawsuit, they have to undergo a mediation process. And do you think mediation should become mandatory before filing certain categories of lawsuits?
Yeah, thank you, Mr. Chuk. I certainly think so. I think having a mediation process before the litigation would help. But again, there are certain challenges to it. One challenge being that just around the litigation time, just before the litigation, that is when the parties are absolutely at loggerheads. So the chances of any kind of a mediation happening that time may not be as much as a mediation happening, let's say, after the pleadings are completed or just before the evidence has started, where the parties already know their position and the lawyers also, or perhaps even the judge, would softly be able to nudge and broadly point out what are the aspects of the case which may not really fly. So, having said that, I would certainly think it's a good idea. In fact, in the Indian context, our Commercial Courts Act mandates that there has to be some a pre-mediation process, which is a mandatory process that is stipulated with which were the amendments which are brought in the 2015 Act, essentially to make sure that frivolous cases do not go into litigation. In fact, Mr. Chuk, I'd like to take this answer a bit further and say this. Not just after the litigation has been filed, I think it is very important for lawyers also, and again, it depends on the lawyers who are advising people. Just around the time the dispute is brewing, when some kind of notices have been exchanged, I believe that it is at that time when mediation would be the most effective, because parties have still not filed any petition in court or they have not contemplated anything there. I believe that a majority of cases, if they're resolved at that particular stage, would be resolved finally, because a lot of egos are at play in the initial stage. If those egos are managed, if client expectations are handled, I see a lot more effectiveness of mediation at a stage just prior to the filing of the actual litigation being initiated and when notices are being exchanged. And this I'm saying from my own personal experience, where parties were able to see sense in the fact that there's no point in litigating. Notices were exchanged. Thereafter, the parties got together and then they just resolved it. I think it ultimately comes down to how the parties are also willing to approach the whole process of mediation and the lawyers who are advising them.
Good, thank you. So Lakshmi, there's lots of questions on divorce since I started asking you all of a sudden. I guess some countries have a divorce rate of 20, 30, 40, 50, 60, 70, 80%. India used to be one. I don't know what it is now, but it's picking up. So there's lots of questions. So I'll come to you in a minute, but let me put these questions together and come up with one joint big question. And the question is, could you share with us, in your experience, the last 10, 15 family matters you handled? Could you share with us two or three of them that ended decently well and through mediation? And how was it done? And I think people want to know, like, how does the split happen and who pays for what and who paid for the mediation? And how was the alimony or child support decided? So if you can give us and to the mediator's help, is there a software? These are the kind of questions. So I'll come to you in a minute. But Mr. Mata, I have a question for you. What are the most common mistakes companies make when drafting arbitration and mediation clauses in their contracts?
Common mistakes. The most common mistake is seat of arbitration, because seat of arbitration is important for the purpose of the logistics, for the purpose of expenses, and for the purpose of running the matter where the seat is. Number two, unfortunately, and I'm going to be blunt here, arbitration clauses are like boilerplate clauses. People just pick up a clause unconnected with the matter for which the agreement is being set up or being formulated, and they just pick up a clause and put it there. Sometimes there are conflicting clauses in the main body of the agreement and the arbitration clause, which hasn't been kind of gone through. Navneet, this is coming from the heart. India is not a healthy arbitration environment. I'm sorry, I've got to be blunt. I mean, for the years that I have behind me, I got to be blunt and say so very clearly. It's not a healthy environment for arbitration for a variety of reasons. We don't need to go into that. All the more reason when an award is going to have the same force as a decree of a court. There has got to be some degree of order in the proceedings during arbitration. It is those clauses which, when drafting an agreement, an arbitration protocol can incorporate some of those things which will make the system far better. Today, the tribunals, in their own way, I'm not accusing anybody, but the experience of all of us is there that not all tribunals act in the way as the Arbitration Act envisaged it had to be done. So, answer to your question, while drafting the arbitration agreement, please incorporate certain procedural aspects of how the tribunal would have to operate. Seat, of course, is one of them. Applicable law, in case we are looking to cross-border or whatever it is. Those are the 2 or 3 areas where a drafting counsel could lay stress.
You didn't want to get into it, Mr. Kumar Mata, that India is not a very healthy place for arbitration mediation, but it's a very
Navneet, 1 minute. Day before yesterday, a former judge of the Supreme Court, no names given here, we all know we are talking about, has said India is ranked as 2% in the choice of preference as an arbitral jurisdiction world over. It's a former judge of the Supreme Court saying that. So I don't want to go into why and what.
right. But I do, and so I won't bother you. But I'll ask Lomesh and Shreyas for the top 2 reasons why that is so. Lomesh?
Sorry, Mr. Chuk, there was a lag. Could you please repeat the question? What are the, you want me to just add on to what Mr. Mata said?
No, so it was said that India is not a very healthy place for arbitration and mediation, and I want to know
No,
why.
not mediation, not mediation, not mediation.
Okay, arbitration. Okay, arbitration, and I want to know why. So at least we can then think about fixing it. So what are the top 2, 3 reasons, Lomesh and Shreyas?
Shreyas, would you like to go first?
L comes before S, Lomesh.
Okay. I was hoping to deflect it to S, but okay, I'll take it on first. Okay. So I think there are a couple of reasons. One is I think at least the problem which was there earlier was the court interference in the arbitration process, which I would say, I must caveat and say that it has largely improved the last 10 or 15 years. If you're talking about a time when the amendments came about in 2015, the position was quite bad, where we had jurisprudence on multiple areas of the arbitration law which needed fixing. But I must say that in the last 11 years or so, barring few judgments which I would say are an aberration, I would say that largely the jurisprudence in India has evolved, but there is a little more work that needs to be done. The second thing is on the, I would say that the professionalism in terms of how the arbitration itself is conducted. When you compare it with some of the Western jurisdictions, I think a lot more needs to be done. There is a movement that is going on within the country on having a specialized arbitration bar, just like how you have in Western jurisdictions. And I can tell you that there are people in the country like Shreyas, Pramod Nair, and a lot of other arbitration practitioners across the country who have made a name for themselves in handling arbitrations, as a specialization in addition to other things that they handle. But we need that kind of professionalism where a counsel says, I will handle only arbitration work and not do court work from morning to evening and then do arbitrations after that. That is work in progress. That needs to happen. And 3, I think the quality of our arbitral awards itself, which again comes down to with the point which I made earlier, which is that we need training. Of course, when it comes to retired High Court or Supreme Court judges, they are trained in judicial thinking and how to apply their mind and pass recent awards. But if you're looking at a pool of non-High Court, the non-retired High Court or Supreme Court judges, then I think they need a lot of training. And that is where I think specialized courses help, because drafting an award is not easy. I've sat and acted as an arbitrator in some of the disputes, and I can tell you it's not as easy as drafting a petition or a plaint before a court where you can afford to pretty much be as elaborate as possible. It requires a different level of skill. And the moment your quality of awards improve, the chances of that getting set aside in a petition before a civil court or before a high court under Section 34 of Arbitration Act, that reduces significantly. Because today, while we have adopted the UNCITRAL model and a lot of foreign rules into our own system and have said that, unless and until there is some egregious error insofar as the award is concerned, it should not be set aside. But if there are blatant errors and blatant mistakes that have crept into the award, the court at that particular point of time would be faced with a very, very perilous situation where on the one hand, they see that not setting aside the award would actually cause injustice. On the other hand, also adhere to the UNCITRAL model, which India has adopted, where the interference with arbitral awards is a lot lesser. So long story short, we need to improve the quality of our process and arbitral awards, which is also work in progress. I wouldn't paint the entire process itself to be extremely bad. I have also had instances where non-retired judges who have sat as arbitrators and have done a fantastic job. But again, this is work in progress for our country. And again, I reiterate, considering the strength of the bar that we have, the quality of lawyers that we have across the country, I'm a bit of an optimist. I do believe that it is only going to improve in the future.
Thank you. Shreyas.
Taking a slightly different view from Mr. Mata, the sense of perennial collapse or anarchy pervades the many parts of the world, including the Indian subcontinent, across many systems, and uh, applying it, those general anxieties. We've heard this of our uh, political system, our judicial system, now in this case, our arbitral system. I would encourage a much more careful, studied, empirical uh, analysis. We have been part of two such reports, and as with most reports, they're largely unread. So I will try to summarize why we went through that exercise. The first was an attempt of Mr. T.K. Vishwanathan in a committee appointed by the Government of India, and we held multiple public consultations, and they were also formed as annexures to the report. It was on amendments to the Arbitration Act, identifying the concerns of key stakeholders. And Navneet the expectations of arbitration are very different from different sets of parties. For example, banks think it is a natural expectation that all awards must be in their favor, and they will scream and shout that the system is faulty if the awards are not in favor of a bank. They do not understand the process concerns that other practitioners might say, that there has to be a neutral system of appointment of an arbitrator. The same person cannot be appointed multiple times. These are not concerns that the banks share. Equally, the ODR movement, in the name of technology, is again perpetuating systems where arbitrations are being conducted for 200 rupees, for 500 rupees, for the entire case. There are aphorisms across the world. You pay for what you get. And so you get what you pay for. And so there are systemic anxieties which get resulted in misdiagnosing the problem and then creating solutions which are a little worse than the problem itself. And so in that report, we try to identify each of these fault lines, identify at least the blunt instrument that legislation is. It can only go so far, and then identify and I would encourage people to look at the T.K. Vishwanathan committee report as a testament to its independence. Only one of the members from who's the additional Solicitor General signed the report. Many other persons who were from the ministry and the government side were perhaps instructed or chose not to sign the ultimate report. Second report like this was the MS Sahu Committee for Gift City. And there we tried to envision what India should look like in its judicial landscape 25, 30 years from now. And there have been amendments that have been suggested to the Constitution of India, to the various statutes. We have contemplated a international commercial court. We have suggested perhaps even the creation of a new high court in India, that Indian law 2.0 has to engage with the world, and it cannot create it for itself, by itself. It needs to reach out, and it needs to allow for international judges to also participate in the creation of India law 2.0. And so that report also is largely unread and not engaged with. These could be called wild and impossible ideas, but now these are ideas that are documented as part of a deliberated report and put out there. So I would move away from a emotional and understandable, and I empathize with that view as well as a human, but as a professional, I feel energized by the negative perceptions to set things right. rather than to fall into despair. And I think there the promise of India in its ADR is its multiplicity of problems. The opportunity is to solve them correctly, and therefore I'm very optimistic that with technology, with the attitude, and what Mr. Mata said about the other interests of other professionals, justice is like health is not the preserve of the legal profession, just as health is not the preserve of the medical profession. And so, as we as legal professionals accommodate people who are not trained in the law, but and acknowledge their sincere interest in justice and the legal system, I think there more real, heartful conversations will emerge, and even systems enabled by technology will allow for this sense of despair to transform into meaningful action.
Wonderful, Shreyas. Thank you. A lot to do, a lot to work on. Okay, Lakshmi, give us a summary of what's going on. Give us a glimpse. People are
Sorry to
very
Mr. Chok and to my panelists, but I need to seek your leave to leave this webinar. I
sure.
have a engagement, so please permit me to do so.
Of course. We're finishing in 3-4 minutes anyways. Thank you so
Okay,
much for
then I'll wait.
joining.
Thank you, thank you, thank you.
No, carry on, please.
Thank you, namaste. Thank you very much.
Come back. So Lakshmi, all yours.
Yes. So the narrative of family courts in India, especially through mediation, is in a very different perspective. What we see on ground is people are mostly prepared. They know what to expect out of it. Uh, Either they are ready with what they want, or they are ready to go through the process of how it will go or what they can expect. Uh, in this, the lawyers play a huge role. We prepare them to understand how mediation works, what exactly to expect out of it. And whenever any couple approaches, most of the lawyers, uh, the first initial start or the lookout is to get them on a table, mediate it. Out of mediation centers also, most of the lawyers turn mediators. Will sit across the table, try to explain them what problems can happen when, especially when children are involved and stuff. We try to explain them, try to amend the relationship rather than break it, right? So and this is one of the main purposes why we take them to the mediation route as well. The moment you file for a divorce in case, it might be a single party claim or a mutual consent. The immediate order the court passes is please go to the mediation, finish your mediation, then come back if you have still not resolved your problems. um, Mediation is successful majorly because of the participation of the parties itself. They are, like I said, they're either ready with what they want, or they're ready to go through the drill of what they can get. Uh, so most of the successful mediations that I have seen, I think about 50% has actually ended up in divorce. Not They have not been able to, reconcile with their issues. But the thing is, they were able to at least part ways with an understanding that they can't live together, without having to go to the strenuous part of court. Sometimes this has also happened in cases where one party has approached for divorce and the other party is still looking out to hold back to the relationship. So that is why I feel mediation, especially in family matters, has made a uh, big impact, because a lot of cases do get resolved, including where there are children involved, custody efforts. uh, Usually it goes to the mother because she's the primary caregiver, but there have been cases where the custody also goes to the father with a request, and mothers having career ambitions and not being able to give enough time. Career ambition is not a wrong thing, but not being able to give enough time to the children as a primary caretaker has affected custody cases to end up with the fathers getting the custody. But when it happens in a mediation, things end in a good way. It doesn't end on a bad note. So the children don't have to go through, uh, you know, a bad experience to either be with the mother or the father. So
Is
that
there a
is
software? Is there a software that is being used now to figure out what the alimony child support should be, that the husband's income, wife's income, and expenses are put together in the software, and the software gives you an idea?
no, I don't think so. There might be softwares, but most people don't use any softwares.
Oh.
Uh,
Uh, Lots of jurisdictions have, most advanced countries, OECD countries have software. The number one software is Disomaster, and it's followed by the courts. The judges use it and lawyers use it, so everybody knows what
No,
the number is going
I
to be.
wouldn't say there is no use of software at all. There will be some mediators do use software, some mediators don't. But the courts, I have not seen them using any softwares for these matters. Uh, but it is more of a just to understand a calculation of what the charges of a what the expenses of a child would look like, and then they will pass orders basis. I mean, mediation there is no order at all in the first place. It's just trying to give them an understanding of what they will have to pitch in, and most of it is agreed between the parties. Like, they will agree to do it voluntarily because it's their kids at the end of the day that they're doing it.
So I have a question of all three of you. So in a lot of countries, mediations after,
Sir, one
first of
second.
all,
I think Mata sir wanted to add something.
yeah, go ahead. Go ahead. You mute.
Sir, you're on mute.
Sorry, just wanted to chip in, Lakshmi. On 3rd of June, the Supreme Court has circulated a draft of regulations for adoption of AI. I think all of you have gone through those. And they've asked for a feedback, not long time, just 2 weeks. Why coming in the break unfair, but be that as it may. So that AI is being, the regulations are being circulated for consultation, and then they'll be framed. That would be the kind of software which perhaps Navneetji you had in mind as an aid to, it's for the court, not for the mediator. It's for only people who will make adjudicatory functions, discharge adjudicatory functions. So to courts, tribunals, commissions, etc. But just answering that, I was just adding to Lakshmi that that's the kind of software we can look in a way. That's an AI tool which is being attempted to be now formally introduced into the system.
Very good. So I was saying that lots of countries, they, first of all, the mediation is very expensive in some other developed world countries, runs anywhere between $3,000 to $30,000 for one day. And when you're paying average about 7,500, which the parties split, or let's say 10,000 that the parties split, 5,000 each. And in that 10,000 is included the mediator reading the mediation statement from both parties and a couple of calls beforehand. Some mediators want to speak to the lawyers individually, separately before the mediation, get an idea of where they are. And it includes the administrative time of setting up the call, and most of the mediations are now on Zoom. But because we're paying so much money, nobody even thinks about having a second day of mediation, because even if you buy half a day will be 6,000 instead of 10,000. Some mediators for the 10,000 or say 8,000 or whatever will uh, say 8 hours, but will carry on for 10, 11, 12, 13, 14, 15 hours. And some mediators have this thought that they will stay up all night if they have to for that fixed price, as long as the case is reaching, or it feels like it may conclude. Some mediators will end after it normally ends because people are tired. And my idea of a mediation is to waste the morning and then have lunch, and at 2:30 p.m. Go get a cup of coffee and go take a walk outside the building and come back. And then when everybody's tired at 3 p.m., then I get going. But um, but some mediators will then say, okay, fine, I'll hear from you. We couldn't end today, but I'm happy to talk to you tomorrow or day after, next week. Call me, send me an email, send me a text. I'll continue to be involved for as much time as you want for this to end. So some of them mean that seriously and some just say it. Uh, but uh, but the question I wanted to ask you is, so what's happening these days is that after spending 6, 7, 8, 9, 10,000, the most I've ever paid for is 15,000. And at 4 p.m., the mediator we paid 14,000 to was asking me, hey, what should I do? But that was good. So at the end of 8 hours, 9 hours, whatever, everybody's tired. And it seems like there will not be a settlement today. Most mediators now and most lawyers now say to the mediator, or the mediator says that, listen, I've spent 7, 8 hours with you. I understand the case. I also know the capacity of both parties. I also know what is it that they would be willing to pay, or another $25,000 is not going to hurt the paying party, but it means a lot to the receiving party, or whatever. They won't say it outright, but it's going through their head. That, do you mind if I give you a mediator's proposal? And I always say, yeah, sure, please do. And nowadays, because the mediator's proposal is happening more and more, I'm preparing half of my day to brainwash the mediator to, at the end of the day, give a mediator's proposal that's in my client's favor. And I'm sure mediators, some of them are going to listen to this and for me to say I'm brainwashing, but you know what I mean. And so it works like a charm. It's 90% of the time, or 80, or 85, or 75% of the time. Parties are at one, the payer wants to pay 1 million, the receiver wants to get 3 million, and all day long they've been bargaining and bargaining. So what ends up happening, and this is for the youngsters listening to this, what ends up happening is that there is almost a joke, but some reality, that the plaintiff will always take 1/3 of what they're saying they want. And the defendant will always be willing, at the end of the day, willing to pay 3 times what they said in the morning or their first offer. So if the plaintiff's willing to take 1/3 and the defendant is willing to pay 3x more, then there is still always a delta. There's still a big, huge margin. And that margin is what the mediators try to fill in. So I've done some mediations. So I look at the person asking for money, $1 million. And in my head, I don't hear 1 million, I hear 333,000 because I know they'll take 1/3. And if the defendant say, I want to pay 50,000, I don't look at 50,000. I'm like, okay, you'll pay 150. So for the whole day, my job is then to bridge the gap between 333,000 and 150,000. And after 7, 8 hours of 5,000 here and 2,000 there, and go to that room and threaten this person, go to each room and tell them they have a really bad case and you're going to lose, you're going to win, the other side's going to win. After doing all that drama, at the end of the day, all I've managed is between 150 to 333. There's still a delta of 150,000 more. And then after 8, 9 hours, the mediators will do a mediator's proposal, which is maybe splitting the baby halfway through, or the person who can afford to pay more, maybe a little skewed in against them. And it's amazing. The mediator writes a piece of paper, puts a mediator's proposal on it, gives it to both parties, and says, if you're going to accept it, let me know. And if you accept it, I'll tell the other side. And if you say no, I'm not going to tell the other side that you said no. And maybe the other side said no also. So nobody will know what happened. But if both parties said yes, then we have a deal. Um, I settled a $100 million lawsuit once on a mediator's proposal of $2.7 million. My client wanted to pay zero. The class action group wanted 100 million. 7 mediations over 4 years. In the middle of the trial, the judge forces us mediation and looks at me and says, "What are you doing here? Why aren't you at mediation?" I said, "Your Honor, we've tried it 6 times." She says, "My boss, the head of the Superior Court, has started a mediation company. He's retired. Why don't you go to him? I'll call him for you." "Do you want me to call him?" I said, "Yeah, sure." So she goes back to her room and comes back and says, "He's available and he'll see you tomorrow." This is a Friday. She says that to us on a Thursday. Go see him on a Friday. And Monday, I've ordered the mediator to come to the court, her boss, ex-boss, to tell me what happened and why the case is not settled. With threats like that, of course, we settled for 2.7 million. So sorry for this long story, but my question to you is, are you seeing this mediator's proposal in any of your mediations?
We call them caucus meetings. I don't know what is the terminology used in other jurisdictions. We take consent, we as a mediator, or if there are two mediators. I've done many mediations where there are two mediators, senior and an associate mediator. So we take consent from both parties and say, we seek your consent to hold caucus meetings, which means we will sit with one party, we will hear one party, we will not disclose what we heard from one party to the other unless we feel it is advantageous, and repeat the same exercise on the other end. I think what you said, a mediator's proposal probably was the same thing. We just call it by a different name. And then we share and exchange figures or let's say terms or whatever in relation to the dispute. It does work at times. I'm not saying it works uniformly. It doesn't work at times. But the fact is that when we have the trust of both the parties to permit us to have caucus meetings, it kind of pitches us into a position where we know that the parties look at mediation as a meaningful going forward.
Lomesh?
Yeah, thank you. I would be a little cautious on what a mediator proposal is. Now, there is not a defined term, but if a mediation proposal is where the mediator, based on an appreciation of the facts before him or her, and after hearing both the sides, has his or her own conclusions, and then tries to propose it to either parties that this is how you should be settling it, then that's a bit of a red line. Because a mediator is only supposed to bring the parties together and not suggest solutions unless both parties are specifically saying that you need to provide some solutions. And there is a clever way in which the mediator can also make the proposal. He can only steer the parties towards that so-called proposal so that it comes from one party to the other as opposed to coming from the mediator, because the mediator is not there to decide the dispute. That is point number one. Point number two is, if by a mediator proposal you mean, and as Mr. Mata also pointed out, and I fully agree with him, if it is where there is a caucus between the parties where the other party is not there, and then takes the consent of one of the parties to say, I am going to make this proposal that you have told me to the other side, if you're okay with it, can I do that? And if there's a consent from the party, then you bring it to the other side, then you hear the other side, take a similar consent, bring it to the other side, and then take the consent of both the parties to present this in a joint caucus where the issues can again be crystallized, and to bring the parties together to see whether they're willing to come down on their bargaining position and then agree on a particular figure. I think that's the way the mediation process should work. If your question is whether that is happening, the latter is certainly happening. You see a lot of trained mediators using the power of caucus, understanding the psychology of the parties also. In fact, when I did that course with SIMC also pointed out as to what are the preparatory work that mediators do in order to understand who is the person who's actually going to be the main person who's going to negotiate, read the facts well in advance, and not bring in, substitute their own wisdom insofar as what they believe the case should be, but only steer the discussions between the parties. And which is why I said in the beginning also that mediation process itself is a lot of unlearning. And a lot of mediators, when they act as mediators, they almost act like counsels who are arguing a case on behalf of one party, or acting like a judge who are deciding the case based on the facts of the matter, which they ought not to do.
Thank you. So, Lakshmi, this must be happening a lot in family law, right?
This happens in family law as well as commercial mediations. Yeah. Commercial mediation, I just want to add to what Lomesh said. Yes, there are a lot of caucus meetings that people propose happens, and they will come back with I wouldn't call it a mediator's proposal. I would call it party's proposal proposed through a mediator. Mediators usually do not come up with a proposal because, as part of mediator trainings, they are, like Lomesh said, they're not supposed to be giving a proposal. They're just supposed to bring two parties to come to a conclusion about what they want and how they are going to accommodate each other's asks. So, on commercial mediations, yes, India needs to do a lot of unlearning on that front to understand how commercial mediations can happen. Um, I just want to take one more minute over here. India has been doing commercial mediations for ages, to be very frank. We've had panchayat system where people used to sit together, mediate between property disputes between maybe brothers or two neighbors. For times, we have been doing it. We need that to, I think we are seeing that evolution, but we need to bring it in the light of a systematic or an institutionalized way to how to adapt it over here. It is what works best, who needs it more. So these are the things that mediators explain to parties. He is not influencing them, or he is trying to make them see what they're not seeing. So firstly, the mediator has to unlearn, firstly, to see it in that particular manner, and also to uh, get the medium right to communicate it to the parties, to put it across for them to start thinking in another direction, see different perspectives. This said in commercial, in family courts, it's a lot more different. It There are a lot of emotions involved with a lot of these things, right? There is a marriage either getting dissolved, or people are getting together or back together. They're resolving their issues. Issues can be very, very, very trivial, very small to the other's eyes. Even the mediators feel appalled at times, like what kind of issues these are, why do they have these kind of issues. But yes, they do exist. And in my experience, I have seen, especially family law practicing mediators, they're quite very well trained. They have an idea and a knack to bring both parties to talk across the table. It is, especially in a family dispute, it would have gone to a certain level that the parties don't want to talk to each other anymore. They don't want to see each other. They don't want to talk. They don't want to discuss. It's more of an emotional hatred that they would have developed through years. So it really is uh, you know, a trick mediators play to, bring them together, talk together. Uh, Whether or not it sees a negative or a positive light at the end of the day, it sees some light, which is very important.
Criminal system, and out the 70 million pending cases, a quarter of them are criminal matters. And talk about mediation and settlements in commercial family law. It's happening. Where it's not happening at all is in the criminal world. And what's shocking is in England, 75% of criminal matters are resolved through plea bargaining, which is settlement between the prosecutor and the defense counsel, and they raise their hand and the judge says, "What's your deal?" And the judge looks at the file and looks at the deal and signs. In New Zealand, it's 85%. Australia, it's 85%. Canada, 90% of all criminal matters get resolved through plea bargaining, negotiated settlements. Okay, instead of felony, take misdemeanor. Instead of 2 years, take 6 months. Instead of $10,000 in fine, take 5,000. U.S. state courts, 95% of cases, criminal matters get resolved through plea bargaining. And federal courts in United States, 98% of criminal matters get resolved through plea bargaining. And the number is less than 1% in India. Any thoughts?
You're coming in, Lomesh. You were coming in.
No, Mr. Mata, please, after you. I mean, you should.
Plea bargaining has been introduced into the statute very recently. It didn't have any judicial recognition, so there was no question of plea bargaining then. Plea bargaining today, let me be candid. What is the conviction rate? The conviction rate is pretty low. I'm not giving numbers. Navneet, perhaps you already have those with you. The conviction rate also changes from strata to strata. So the people who know that the conviction rate is low, why would he go and enter into a plea bargaining arrangement where he knows he'll ultimately be A, held guilty, which goes onto your records, B, liable to some kind of punishment, whether a fine or a penalty or maybe some term, and the chance of getting an acquittal being, as it were, the attraction for a plea bargain for that strata doesn't exist. For those for whom the rates are different and who come from another strata, you need a lawyer to tell you as to how to plea bargain, as to where is your best bet. You need the prosecution to be also, fairly advised as to how to engage in a plea bargain. I think we are still much too young in that, let me say, in that environment. That's just my 2 bit.
Lomesh?
Yeah, thank you. Just a few points on this. If you're looking at the statistics of how many criminal cases are pending in our country, and I think I don't have the study in front of me right now, but Niti Aayog has done a comprehensive analysis of how many cases are pending in the Supreme Court, the High Courts, and in the criminal machinery itself, and also pointed out the reasons as to why there is so much of a delay in disposing of some of these cases. I just want to give two quick aspects on this. One is a lot of criminal cases pertain to check bounce cases, 138 cases, traffic misdemeanors, etc., etc. Those are cases where the Supreme Court has also constituted a a committee which is looking at adopting use of technology and AI to dispose of these cases much faster, because you don't need a human to come and just tell the parties as to how much the drunk driving is going to cost, right? So it's you just feed it into the system, and the system should be able to generate that data. And a lot of time has just gone into that. So those kind of cases can easily be disposed of, and that is going to be implemented very, very soon. So that is one. The second thing is, I was actually attending a seminar in which a sitting judge of a high court was also there, and he made a presentation. And we were actually pleasantly surprised to see that in the last 10 years, from 2015 to 2025, the number of criminal cases and civil cases that have been disposed of in this country is at a phenomenal rate. In fact, more than any other high court or court in the world. I can definitely say that, because the pressures that the Indian judges have, no other judges in the world have. But having said that, the pendency is also increasing, because no matter how good your judge is, no matter how fast they dispose matters, and all of them work really hard and try to dispose of matters quickly, but then the system itself allows for a lot of these false criminal cases to also be put into the system, which is again clogging the system and which makes the statistics look bad. But otherwise, I was actually pleasantly surprised to see the kind of work that has been put in just to dispose of matters. And the other statistic which was also put, which again, unfortunately, I don't have before me right now, is on statistics with respect to Lok Adalat. The number of matters that gets decided there is again at a phenomenal success rate. In fact, the percentage is more than 50 or 60% from what I recollect. I could be wrong, but it was definitely a percentage which makes us proud that at least that process is also going well. But having said that, Mr. Navneet, I do agree that there are areas of improvement. Plea bargain is something that, unlike the US, we don't have the system here. We have our own public policy reasons as to why some of these things don't happen on the ground, including confessions to a police officer. It's not admissible here, whereas it is admissible in the US. There are local nuances as to why the criminal machinery needs to be put on a slightly more different footing compared to a lot of other jurisdictions. And again, as I said earlier, work in progress, but I am an optimist, and I do believe that with the use of technology and AI, things would get better, but hopefully at a far more rapid pace than what we expect it to be.
Lomesh, there's a small difference between compoundable and non-compoundable. Plea bargaining is what I was referring to was on non-compoundable matters. In compoundable matters, there's a different arena altogether, which can be compounded without actually, you know what I'm saying. So I thought Navneet's question was probably targeted to the non-compoundable nature of offenses rather than the other ones. Correct me if I'm wrong, Navneet.
I just want the 70 million number to go down to 7 million. That's all. So Lakshmi, you get the final word.
See, also plea bargaining in India is not a very well-known kind of bargaining that comes from the prosecutor side as well. We don't see prosecutors trained well enough to understand plea bargaining in its entire sense. Also, there are a lot of limitations when it comes to plea bargaining, right? Firstly, we've been introduced to this system at a very later stage. I think the first amendment came in 2005, introducing plea bargaining in CRPC, I guess. The understanding of the whole subject is not maybe as good as what it is practiced in the West. The understanding is also much lower here. Not just the lawyers, the prosecutors, and also people who commit crimes would not even know that there is something called as plea bargain until they're told about it, right? But the further issue is the restriction that plea bargaining also holds, like a maximum sentence of 7 years is what offenses which come under those that imprisonment line is what can be plea bargained at all in India. You cannot go beyond that. So your capital punishment issues that are bigger social issues cannot even be, you can't even go and, try them out as plea bargaining, which often, oftentimes like happens more in the West. So most of your crimes are also not your socio sympathetic offenses that happened or crimes that happened in India. But I think there is a big lag between the understanding of how it works, and also there are not laid down rules on how there is no training, there's no laid down rules on how you have to make it work if you're looking at that way. There is a lot of lacuna there. There needs to be practice adaptation. There needs to be understanding of the nature of working of plea bargainings. There has to be more, knowledge sharing that needs to happen in the bar and generally otherwise as well. Also, what applies and what doesn't apply. I think the boundary of this also needs to be re-examined to, I think, make it work better.
Right. Thank you so much. I think if we look at the numbers of 60, 70, 80, 90, 95% of criminal matters in other countries are being resolved by plea bargaining, and it happens very quickly. 1 month, 2 months, 3 months, the case is over. Sometimes it's over in a week. First call, and the prosecutor and defense counsel have a deal. And of course, the judges approve. But if a quarter of the 70 million cases are criminal matters, so that's 18 million I think if we one fine day when plea bargaining will become very prevalent in India, I think we can get rid of 90% of them in 90 days. Hopefully that'll happen. I have a dozen more questions, but we've already gone way beyond what we usually do. That's because you've been so good. I thoroughly appreciate you joining and I would welcome you back. Thank you, Kumar Mata. Thank you, Lomesh. Thank you, Lakshmi, very much. Keep up the great work you're doing. And I love the optimism in the room. Um, I hope that you'll carry your optimism outside this webinar into the real world of India and spread it. And I think us lawyers, and I always say that if you look, make a list of the top 100 people that got us independence, 75 were lawyers. Gandhi and Nehru and Jinnah and Sardar Patel and this and that. So we look at all of the problems we're facing, and the lawyers cannot advertise, lawyers cannot have a website, cannot have a booth at a conference, cannot teach, cannot become general counsels without surrendering their licenses. You can't open a pan ki dukaan. And the worst, that lawyers can't work on a success fee contingency basis. I think the Western world would be a third world country, but for the contingency success fee lawyers. And we have 70 million pending cases, 100,000 in the Supreme Court of India. I think all these are humongous, huge problems. But look at what we did in from 1857 to 1947. We kicked the British out without guns and this and that. So what is the big deal about fixing this system now? And if we have this optimism we have in our webinar today in the entire legal system of India, I think we can fix all these problems. Thank you, thank you, thank you so much for joining.
Thank you
Come
so
back,
much.
please.
Yeah, thank
Come
you.
back.
Thank you so much.
Somebody asked for 2 reports that were mentioned. I'll put that in the chat. Thank you. God bless you.
Thank you.